Well, hello there, everybody. Welcome, 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 man. I am so happy, so pleased to have everybody tune in. We have a wonderful audience out there, and we are always happy. We're always overjoyed, in fact, overflowing with joy to bring you guys the best information so that you can use that information. The more you know, the better off you are, right? And I'm so excited. I could barely sleep last night, right? Because today we have with us a very special guest, a first time guest, right? Never been with us before, and I hope everybody can give a big virtual warm welcome out there to our guest for today, Ryan Kahn. Now, Ryan is an accomplished entrepreneur and a transformative leader with a unique background spanning law enforcement, business consulting, and he had a distinguished career as a detective sergeant and SWAT team leader. Interesting stuff. I'm sure we'll have lots of conversations about that. Now, Ryan honed his skills in leadership, strategy, and team building, transitioning to the business world, quadrupled revenue at Sheldon Associates in just 3 years, 3 short years. That's amazing. Now, as a founder of CS Business Consulting, Ryan empowers companies nationwide to cultivate high performing teams and influential leaders. A dedicated community servant, and a published author. Congrats on that. Ryan brings his expertise and passion to every endeavor and driving success and positive change wherever he goes. He leaves the world a better place wherever he goes, man. Ryan Kahn, thank you so much for being with us here on Legal Talk, and welcome, welcome, welcome to the show. How are you doing today?
I am doing great, John. Thank you for inviting me on and having me, and thank you for flattering me with that introduction. I'm just happy to be here speaking with you.
Yes, sir. Oh my goodness, man. Today is a wonderful day, man. It's a Tuesday, which I just told one of the staff here at the office. It is a Hump Day Junior. So we got that to look forward to the rest of the day. But for the moment, we've got some interesting topics to talk about. We're going to chat a little bit about navigating business consulting for legal professionals. Very important stuff because a lot of times we lawyer types we might be good at what we're good at, which is laser focused on the law, right? So we might know the law, but we don't know a lot about business, maybe. And when you hang that shingle out there, I mean, you're not only an attorney, you're a business person. So that's what we're going to talk a little bit about today. So, first question that right off the bat that comes up in my mind, right? How can legal professionals benefit from business consulting services?
Wonderful question, and I think you really led into the answer on how they can benefit in realizing that you get laser focused on what your area of expertise is. And we really need to be able to rely on other experts in other areas to help refine us and bring us up to our next better, higher level. And if we can basically humble ourselves just a little bit to say, hey, I may be the most amazing attorney in the world, but I am not leading my people through workflow. I am not mentoring and developing my people. I am not doing X, Y, or Z. We can struggle and strive and dig around to try to create those answers ourselves, effectively reinvent the wheel, as people say, or we can rely on someone to come in here, take a deep breath and say, hey, you can make change A, B, and C, and that will drive you to your future. So one of the huge benefits is that you don't have to take on a whole nother hat and try to become this shining entrepreneur. You can stay focused on your niche, your area of expertise, which is driving home the area of law that you're in and being as successful as possible in the courtroom, in the briefings, in the mediations, and just be your highest valued self.
Well, that is great information, man. I'm happy to have that wonderful answer for you. Hope it is well serving to everybody out there. And so I can tell that you are not new at this. Been not your first rodeo, been around for a while. So, what are the common challenges that law firms face when that consulting could kind of help address?
I love that. One of the primary areas that come into the big picture is delegation and teamwork, getting that flow going together. So if we can get the delegation and the team working in a model where they all interchange workflow, they pass things off to each other, and then they work for the maximum efficiency and effectiveness of that end goal, which is a successful case. then we can really elevate our next level. And then the second really area is that the attorney is the one-stop shop for all sources of expertise. And creating initiative and drive in various members of the staff to present examples, present case law, precedents, various proceedings and procedures, then the attorney can become more of that step back role, just being the surgeon that shows up and makes the surgical cuts, the final decisions. And there's a development process to that. There's a methodology to that. There's materials, of course, that need to be put in place, whether that's software or communication channels, and then driving that vision of the team working together to accomplish that common goal. That's the area where sometimes we just show up and do the work, do the work, do the work, and whatever chaos comes with that process, we can really drive down the chaos or completely eliminate it.
So basically, what you do is remove a lot of the background noise and let the expert do what the expert does, and kind of help guide the firm, to be more efficient and be able to work a little bit better, and let the guy focus on what he's going to do, supposedly, right? So that's great. So how in the world do you tailor your consulting approach to be able to meet those specific needs of law firms?
That's a wonderful question. I'm glad you asked it. What I tell people is about 80% of entrepreneurs, or about 80% of the problems are all the same across entrepreneurs, across industries. And the tailored approach really comes in on that last 20%. What's different between, of course, an accounting firm, a attorney law firm, a construction company, or coaching a baseball team? They all require leadership and organization workflow, the team dynamics, but that last 20% that makes us all different, that leadership realm, I come in there and identify your workflow. I identify your culture, the characteristics of your team, and how to put those pieces together. So everyone's teams are different. Everyone's personnel is different. Their softwares and their communication channels are different. So the principles that I bring are 80% of the material is going to be universal, but that last 20% takes you from being a B minus student to getting the A plus. So that comes in with literally blowing apart the big picture of how you process things A to Z, right? And then we examine each piece, we eliminate duplications, we put in purposeful funnels to make sure that there's checks and balances, and we assign the right people in the right places to automatically work those channels and elevate everyone, and most importantly, that highest value attorney who can focus on their highest purpose for the most amount of time.
Man, oh man, this is great stuff, man. I hope everybody out there appreciates the depth and breadth of what we're getting here. Now, I know I was very competitive back in school, and I love getting that A plus. So you had me at A plus, man, and I'm sure that I'm not alone in that. And again, I know that I can just tell this, right? It's our first interview. I can already tell you are not a guy that has been at this just a few weeks or a few months. You're not your first rodeo, been around for a while. So what kind of success story can you share with us? Is there any kind of success story you can give us about how you've helped transform a law practice?
Sure. And I'll kind of give you a three-pronged approach because I do want to really explain to people that this is a person issue and a leadership issue before it is any other technical issue. One of my first success stories when I first began having the opportunity to rebuild a team was actually with a organization you guys know as the Special Olympics, and a local chapter needed a lot of help. So I jumped in there and helped them create systems and things that, of course, there's a lot of legal issues involved in that one and liability, and create systems that effectively created and reformed our program. And then I formed high performing teams in multiple areas. I both was on a SWAT team and then ran a SWAT team for over a decade of that, and building teams to be the highest performing people under stress possible. And then developing now 7 of my own companies into high performing companies. And then ultimately, I've worked with a handful of law firms. One law firm was a very successful story because it was a tax attorney who owned a legal law firm and then owned separately an accounting firm. And having the appropriate blend and building the wall down the middle that has to be separated for all kinds of legal matters, that was very important. And the people were very much, well, we're the law firm and we're the accounting firm, but they were technically under one big umbrella of leadership. So breaking down those silos for the team model while maintaining the legal integrity of the two firms was of the utmost importance. They were able to increase their revenue in 25, 26% in about 6 months. And then the law firm was able to really expedite their mentorship program, which was bringing on interns and having a path to check off their growth and then retain that intern as a permanent staff member later on. And then more recently, I helped out a law firm that specializes in corporate law, business law, and we would go in there, and the partners were not exactly cooperating with each other, and they had different mindsets. So the of course, the staff and the resources were owned by the firm in general, but how they delegated to each other is I have mine and you have yours. Once again, a little bit of that silo mindset. And getting everybody to play ball together and establishing that your mission is something specific. Your mission is something that is not just a wall hanger. It is what you show up to do every day. And the two of you are violating the mission in the way that you're conducting yourselves. And it's breeding a bad culture and it's breeding divisiveness. So bringing them together to come with a master workflow, because one partner would tell somebody to do things one way versus the other way, and come up with a master workflow and having them share their successes on either side, so that again, even though we feel like we're in two different houses, we're really one big team. Bringing that together allowed them to move through case files quicker, have more timely client responses. Ultimately, they could host meetings and get their information and deliberations done faster and more effectively. And they were able to pick up the pace of business at that point. And their metrics are still ongoing because this is my newest law firm that I've just taken.
Excellent, man. That is a great story. And so we only got a couple of minutes left. Let me just get through these last couple of questions for you. So what's next on my mind is what kind of steps, let's say somebody wants to hire you as a consultant, they need to, brush up, polish up their law firm, so to speak. What kind of steps should they take to get ready before they hire you?
So one of the things I do is I create a problem and solutions list, and I'm a very transparent person. So you need to create a list of the top 5 to top 10 most painful things you're experiencing right now. And then you need to, after you get the complete pain points list, now maybe start with 5 for simplicity's sake, and that way you don't get too negative, come up with a 5 solutions list, okay? And what needs to change to make those 5 problems go away? And literally put them in 2 columns beside each other. And here's the caveat. If you start building the solutions list with Johnny needs to change and Sally needs to do more of this, you're looking at the wrong list. Your list needs to start with, I need to do this. I need to example here. I need to create more bandwidth here. If your list is not littered with I statements, you're looking at the wrong list. That is the first place I would tell everyone to look, is in the mirror and what they can do to change. And when that opens up your eyes, you're ready for some serious consultation and some serious work to get that done.
Man, oh man, Michael Jackson said it, right? The man in the mirror. So be that change that you want to see. So that is a wonderful, wonderful first step. I'm sure people are going to take that and then they're going to pick up that phone and call you. So tell me, just last thing of the day, how should people reach out to you if they want to get some good consulting services?
Well, appreciate that. So our phone number is 270-442-6688. And that rings to both Shelton Associates and CS Business Consulting. Just tell them which one you want to talk to. And then our website is csbizcon.com. That's csbizcon.com. And you can schedule an appointment right online, say the reason why you want to meet, and you'll get on my calendar and we can start chatting and getting those services going.
Man, oh man, that is some good stuff, man. Congratulations, Ryan. You're doing a great job, obviously knocking it out of the park. And I would highly, highly recommend that anybody out there that's watching, legal professionals, they want to, get the best they can out of your law firm. You spent years and years studying and years and lots of debt, going and getting that law degree, opening up a business. And now you want to make sure that you can squeeze the most out of that business, get the most out of it that you possibly can. And that starts with, getting Ryan on board, get some good consultants so that you can, move down the road with that. So thanks very much, Ryan, for being with us on Legal Talk. We really, really appreciate it. And I am greatly looking forward to having you back on the air again with us next time. Well, hello there, everybody. Welcome back to Legal Talk. I am overjoyed today because I have a very special guest, Miss Ingrid Perez, immigration lawyer extraordinaire, expert in all things immigration, and she has set aside some of her very valuable time to be with us here today on the show. We are so appreciative. So, Ingrid, welcome back to the show. Thanks so much for being with us again today.
Oh, so you're so welcome. Thank you for having me.
Absolutely. Well, look, we have got some great questions that have come in for us to talk about a little bit on the show. Hopefully, you can shed some light on this stuff for us now. So, what is starting off? This first question, it really has me, intrigued. I'm waiting on pins and needles. I'm on the edge of my seat, so to speak, to see what you're going to say about this. So, let's say you got a small or medium enterprise, a small business owner, medium business owner. What pathways, what immigration pathways might be available, assuming that those folks want to expand their business to the United States?
Yeah, absolutely. I know immigration is very exciting, so let's talk about it. So, for a small business owner or a medium-sized business owner, the first question that I ask is, what country of nationality are you? Where were you born, right? Because if you were born in a certain country, what we call the treaty countries, like for example, Mexico, Colombia, Spain, Argentina, France, some of these countries have treaties with the United States that allow foreign nationals to come to the United States, open up an enterprise here, whether it's a subsidiary or not, as long as as long as the entrepreneur has the nationality, they can set up shop here in the United States, open a business, create American jobs, and they can come to the United States with what's called an E2 visa that gives them permission to live and work in their business in the United States. Their spouse can come, also have work authorization. Their children can come and go to school, and they're able to benefit from this visa until the age of 21. So that is the first sort of option. Another option for perhaps maybe the medium or medium to large businesses outside of the United States that are more multinational companies, you can also set up a subsidiary here in the United States of that foreign entity and transfer a manager or an executive here to the United States to run the operations in the US. At that point, we're talking about a true subsidiary, a foreign company with a subsidiary branch here in the United States, transferring a foreign national to run the operations here. So that is option number two, and that is typically done through an L1 visa.
L1 visa. Yeah, I have heard about that, but I did not know, the specifics of it. So thanks for letting me know. Now, question number one, we were talking about immigration pathways if they're looking to expand their business in the United States, and you mentioned certain countries have a little bit of extra benefits, treaty countries. But that made me think, what would be the case if a person, for example, has a dual nationality? I know a guy who was born in Mexico, but his father was a British subject, and so he has a British passport and a Mexican passport, and now just recently added a U.S. passport to that. So he doesn't need any special visa to come to the United States. He's got the big blue passport, come anytime he wants, right? He's coming to
Yeah.
his home, right? But let's say a person has more than one nationality, and one of their nationalities is with a treaty country. Can a person like that choose, to, I guess, come under the auspices of a treaty? Like if you have dual nationality, can you
Yeah.
choose which nationality is best for you in this immigration type circumstance?
Yeah, absolutely. I have clients in this specific situation. For example, I deal with a lot of Brazilian nationals that have dual nationalities, that they have an Italian passport. They were born in Brazil, but they have an Italian passport, and we're able to get them E2 visas with the Italian passport. And now the spouse and the children do not need to have an Italian passport. They are the dependents of that Italian national, and they can come to the United States even if they don't have the nationality, which is nice. It's a nice perk.
Oh, so is it all right? So that thank you so much for that information. I did not know that about the spouse and the kids. So that's that's a good thing to file away up here. My filing cabinet's pretty full. I might start losing stuff soon out of it, but but we'll keep that information up here and know it for the future. Now you talked about what was did you say was it L2 L1 L2 about the subsidiary? Does that have kind of a similar type of a benefit for spouses and kids?
So the L1, we're now talking about multinational executives or managers coming to the United States to run a subsidiary. There's no requirement that a person has a specific nationality. Really, here what we're looking at is whether the foreign company can open a subsidiary here in the United States, create several American jobs, and transfer that executive over here to the United States. The spouse and children can come to the United States with L2 visas. That is a dependent visa. And similar to the E2, the spouse can work, the children can go to school, and an extra perk of the L visa is that it's a dual intent visa, meaning it can lead to permanent residency, the coveted green card, whereas the E2 is non-immigrant, you have to keep renewing it. The L2, a little bit better because it does lead to a green card, which is something very coveted for a lot of people.
Oh my God. Yeah. See, that is excellent. Oh my goodness. Okay. So my last question, I guess, is what would be the visa options for employees that are transferring to the U.S. to work at a branch, let's say a branch of a foreign company?
So, in the E2 context, if the employee has the same nationality as the E2 company, so in that example before, a Brazilian national with a Italian passport opens a company here in the United States and they want to bring an essential employee, they can do that as long as the essential employee also has the same nationality as the company. In this case would be like an Italian passport, right? In the context of an L visa, companies can transfer employees with specialized knowledge through the L1B visa, and that is something that I've actually done not that long ago. I worked on an L1B visa for a company with headquarters in Brazil and a subsidiary here in the U.S., another subsidiary in Europe, and they needed to transfer an employee that had very specialized knowledge about their systems. It was a logistics company, a freight logistics company, and she needed to come to the United States to work on their system and train the employees because she had this very specialized knowledge. So you can definitely do that.
Excellent. Oh my God. Well, this is just like drinking from a fire hose. So much good information. We really appreciate it. And folks out there, I hope that this illustrates how important it is to have somebody like Ingrid on your side if you're trying to navigate these complex waters, right? So Ingrid, I do really appreciate you being on the show today. And please tell everybody if they have some kind of an immigration situation they want to discuss with you, how would they go about finding you?
Go on my website. All of my information is there. It's www.ib as in boy, p as in Peter, law.com. You can send me an email, give me a call, send me a WhatsApp. Uh,
Oh my God. Well, that's wonderful. That is plenty of good ways to get in touch with you. So it all starts with go into that big website, IBP. What was that? Please tell me that one more time. Is IBP? IBPlaw.com, right?
ibplaw.com.
All right. Well, that's excellent then, and thanks very much for being with us. We appreciate it, and we will go to some commercials, and we will be right back here on Legal Talk. Well, hello there, everybody. Welcome, welcome, welcome back to Legal Talk. I hope you had a wonderful little commercial break there. You got a chance to stretch your legs, get the warm or cold beverage of your choice, as the case may be. And you are back, and man, oh man, I'm so excited, right? So excited because today we have with us again attorney extraordinaire Mario Varela. I am so happy because every time Mario comes on with us, we learn something new, and I am really hoping that you folks out there in the audience just really understand and appreciate the wonderful information that you get in from Mario, right? So Mario, welcome back to the show.
Thank you, John. Thanks for having me.
Absolutely. All right. So today we were chatting a little bit before we got started with the segment, right? We were chatting a little bit and we were talking about what we're going to talk about today. So today we're diving in a little bit, kind of scratch the surface, kind of get our feet wet a little bit, so to speak, about contract law. Right. So if you could, Mario, it would be greatly helpful for the audience out there just to kind of I guess kind of get our feet wet and refresh our memory a little bit, right? Let's go back to law school, right? And let's go over what are the essential elements of a legally binding contract.
Certainly, John. There are several components or elements of a contract that is legally binding. One of them is that there needs to be an offer. Normally, one party will make the first move and will make a clear and definite offer to the other party, and the offer must express the intention to enter into a contract under certain terms and conditions that should be described in the contract. Second part is the acceptance, and this is where the meeting of the minds concept comes in mind. The second party should agree and accept the terms of the contract without any conditions or modifications, because if there's anything that they don't agree with, it needs to go back to see if the first party is still okay with the different conditions or modifications to the contract. And normally there's also that there are probably some ways that that acceptance must be expressed. One of them, for example, it's probably described or should be described in a good contract. What's the proper or correct way to accept the terms of the contract? It could be by signing the document. It could be by starting to work, to do the work. It could be verbal agreement would be okay, so on. The third component is that there must be consideration. This is kind of a legal concept, and it means that there must be some sort of mutual exchange of something of value between the parties. And consideration can be money, can be goods, services, promises, or anything else of value. And the next element, of course, has to be intent. Both parties need to intend or have the purpose of creating legally binding relationships. And there are certain other requirements, legal requirements, for example, capacity. That means that the person should be, should be of legal age, and there should not be any coercion, any undue influence, any type of fraud. So that's also important. The contract must be legal. The purpose of the contract must be legal and not against public policy, meaning that contracts for illegal activities are not enforceable. There must be certainty on the terms of the contract. This is always very good practice, because I've seen the classic contract written in a napkin, and there's not much room in a napkin to write the terms and all the things that can probably happen in a contract, in a business contract relationship. So it's always good to make sure that everything is spelled out, and that takes some time. And we know that whenever something is vague or ambiguous, that is probably going to lead to disputes later. So that's the time to do good planning and write with very good definition, with certainty, what the key terms of the contract conditions are. And other than that, we have certain formalities for some types of contracts. Not all contracts need to be in writing. It's always a good practice, but there are certain requirements. There are certain contracts that are required by law to be written in order to be enforceable. For example, those like real estate transactions, those typically require a written contract to be enforceable. So there you go, John. That's just a brief rundown of the most common elements of a contract.
Man, oh man, every time I talk to Mario, I feel like I'm drinking from a fire hose, man. That is so much great information, and we really do appreciate it, Mario. So now let's say, now that begs a question in my mind, right? Let's say that I want to enter into a contract with somebody, right? So I'm going to enter, I've got in my mind, I want to enter into this contract But of course, as we can imagine, the first thing you do when you're going to enter into a contract, you want to, negotiate that, right? You want to get all those terms and conditions understood and agreed to up front by everybody. So how can a business go about protecting itself if you are entering into some contract negotiations?
Well, would really recommend that contracts are well thought out, that they're well planned. I mean, just entering into a binding contract in the spur of a moment. I mean, people have second thoughts. People cannot think of all the possible things that could go wrong and so on. So it's very important to give it some thought. It's important also to define the expectation we're looking to get from the contract, define also the terms that are and the conditions that are most important and relevant for the contract, just so that misunderstandings can be avoided. Also recommend, of course, that they seek legal counsel, just so they can review the terms of the contract. Because attorneys, we get to see a lot of contracts, we're kind of familiar with some of the most common terms and some of the things that could go wrong, just because many times we get to work on cases that really started from a contract that was not well planned. So many times the contracts or the disputes will come because something was not addressed or anticipated in a contract or documented, and as a result, there's a difference of opinion, and each party wants to go their own way, wants to have their the dispute resolved in their favor, but of course, we have to consider the other party. So it's that's why it's always good to get a legal counsel involved from the beginning. The next thing would be to conduct due diligence. We want to look at the reputation of the other party, their financial stability, their legal standing, and so on. There's a lot of homework that both parties should be engaging in before signing up for a contract. There's also something that should be documented in a contract, and that's kind of what I like to call a exit strategy. Let's say that we plan to do things certain way, this is what we want to do, we both agree, but somehow, somewhere down the line, something's not working for a number of reasons. Sometimes there are changed circumstances and so on. So in this case, I want to have a way to terminate the contract, and of course, protecting each party, just to make it a fair option for both parties. And there should be a methods for dispute resolution, for limiting liability, confidentiality, intellectual property rights also need to be considered. So there's a lot of things that we want to put some, make it clear what our needs are, and also put some teeth in that contract, just so we have a way out or some sort of remedies and indemnification clauses in case the terms of the contract are not followed. Of course, we also look to negotiate favorable terms, and just keep in mind that we will need to compromise on certain points, just because the contract needs to be fair to both sides. We need to be careful with avoiding ambiguity, just because that's kind of where the problems start, when people have different understandings or things are not defined, and that can create problems for down the line. We also need to anticipate what could possibly go wrong. We have had a number of things that were not anticipated. For example, everyone still remembers the pandemic, and that was, I'm sure it was unforeseen for everyone, but those are kind of things that can impact the contract. So as much planning and anticipation we can do, I think that'll go a long way to help us stay out of trouble. Some contracts go for long, extended periods of time, could be for years. So it's always a good practice to review those contracts periodically, just so that we can just to see if they are still addressing the needs of both parties. And occasionally, many times actually, we should also consider coverage, insurance coverage, just in case something doesn't work the way we planned. Insurance policy, just such as liability insurance, errors or omissions, business interruption insurance can also provide added protection. So there you go, John. Those are some of the ways businesses can protect themselves in contract negotiations.
Man, oh man, good stuff, sir. Good stuff. So just one final question, because we're almost out of time for the segment, but I want to get this last question in so that we can make sure everybody has a kind of a full and complete picture of things. So let's say despite our best efforts, things have kind of gone off the rails a little bit. So what kind of steps should be taken if there is a contract dispute?
The very first step is always to go back to the original contract. That's the very first thing that everyone is going to go by. It could be the judge, it could be a jury, it could be the mediator, arbitrator. Refer back to the contract. It's always very important to have to keep a copy of that contract available. We also need to be try to maintain communications with the other parties. When two parties are in a dispute and it gets so bad that they're not even to talk, not even able to speak to each other, that really makes it difficult to come to a solution. And always be flexible, consider the other side. I mean, you still have to be firm with certain things that are important, that are really required for you, but just need to consider that also the other side has their own side of the story. And then we have there are different parties always consider, well, we're going to court, and just consider that litigation is an expensive option. So that's why certain other forms of alternative dispute resolution are available. One of them is mediation, another one is arbitration, and as a last resort is litigation. But again, this is going to take months. Sometimes it can take years, and it's expensive for both parties. So just really should be getting support from legal counsel to proceed if that's what they want to do. So that's essentially it. John, in case of contract disputes, that's kind of the things that we should be keeping in mind.
Well, there you go. But the big takeaway for today is try not to have a dispute, because, they taught me in law school. I'm sure they taught you something similar. A bad settlement's better than a good lawsuit any day of the week, right? So definitely gonna keep that in mind. So keep legal counsel in the loop. Get your counsel involved early and often, right? So how do you do that? How do people do that if they want to call Mario? How do they get in touch with you, sir?
Certainly. Our number is 713-684-3550.
All right, 3550. Got you. That is wonderful. Hey, well, thank you, Mario. We are going to go to a couple of brief commercial breaks, give folks a chance to stretch their legs a little bit. And we're going to hear from our sponsors. And as soon as we do that, we will be right back on Legal Talk. All right, excellent. Welcome back, everybody, to Legal Talk. I hope you had a wonderful commercial break, and now we are back ready to get some final segments, some good information from superstar attorney Mario Varela. Great attorney, great guy, know him personally, and very happy to have Mario back on the show with us. And I will just jump right in with the very next question, because sometimes, Mario, talking about business litigation, right? You said that's our last resort. Sometimes you end up in the last resort, man, despite your best efforts. All right. So what are some of the most common causes that you've seen that, situations that lead to business litigation?
Well, the first one I would have to say, contract disputes. Sometimes in the life of a contract, there's misunderstandings, and things get to the point where one of the parties is not able to live with the terms of or the expectations of the contract. So that would be the first one. excuse me. The second one would be employment disputes. That's just disputes that normally arise from the workers, could be employees, could be contractors. So sometimes it could be current or former employees. So that's just a completely different chapter, labor law, that really requires just to stay abreast, up to date with employment regulations. There can also be disputes about intellectual property rights. Could be trademarks, patents, and so on, copyrights. Many times partners will get into disputes about a number of things. It could be profit sharing, could be management, could be decision making. There's also a possibility of getting into compliance issues with the government, tort claims. That's when there's some sort of damage, when there's no contractual relationship, for example, when there's property damage or any other type of harm that is caused by negligence or intentional actions. So that's could be also accidents, could be product defects. So a number of things that could happen that could create a cause of action. Debt collection is also a common cause of action that will create a dispute for one party trying to get paid. We have cases of fraud and misrepresentation and breach of fiduciary duty. That's when a person has, or a party has, a heightened duty to look for the keeping the best interest of the other party in mind. And of course, we also have the competition disputes. That's also something that can happen. So that's the reason of having non-compete clauses in many contracts. So there you go, John. That's kind of a brief rundown of the kind of causes of action that sometimes arise from business relationships.
Excellent information, man. I appreciate it, Mario. Thanks so much for that. Now, here's my next question for you, though. All right, so let's say that I'm looking out over the horizon, right? I see some storm clouds, right? Not like the ones from the other day, but I see litigation type storm clouds, right? Potential for something to come up. You know, what kind of things should I do to prepare for that?
Yes. The first one I would say would be to maintain accurate records, and there should be a record retention policy. But in general, it's always a very good practice to have everything or as many things as possible without making it too burdensome to have things in writing. Policies, procedures, records that things actually were done or what was done, who did it, and the date, a brief description of what happened or agreement that they came up with. So that really a long way to solve problems and to anticipate and prevent problems. We also need to keep in mind of our duty to comply with laws and regulations. And of course, as part of management, reviewing contracts very carefully before signing them off. That's always very important. We also need to consider strategies for mitigating or managing risk. That could be insurance coverage and just conducting risk assessments. It's also a good idea to work always with legal counsel, so that there's another pair of eyes. They're looking at for things that could be too much for just one party to look into or to stay up to date with. Talking about compliance issues, contract negotiations, potential legal risks. It's also very important to train our staff just so they know what needs to be done and they are prepared to deal with the day-to-day activities they're responsible for. And also we have to consider whenever there's a dispute, consider alternative dispute resolution methods such as mediation and arbitration. So there you go, John. That's kind of essentially a brief rundown of how companies can prepare for business litigation.
Okay, well, final question for you then, Mario, because I'm now, you got me intrigued, right? Now, as you mentioned, arbitration, mediation, et cetera, so those are all alternative dispute resolution methods, alternatives to litigation. Let's say what strategies can be employed to resolve business disputes effectively?
And we should address them. Parties should address those their concerns early in the process, just before they get out of hand. They're addressing concerns with the other party. That's why it's very important to maintain open lines of communications open. And of course, we need to treat the other party honestly, to be honest, and very respectfully, because we don't want to want to make sure that we still maintain the respect of the other party. And occasionally, when there's differences and concerns, we need to be open to negotiation. Not every time the disputes are going to be resolved in our favor, but at least our point of view will be considered. And many times it's a matter of settling for something. Usually there's not even a clear winner. Usually each party will win little and will also lose something. But we just need to be open and flexible and open to negotiations. As far as alternative dispute resolution methods, we have mediation, which is when a neutral third-party mediator facilitates the discussions and helps the parties reach a resolution. And the other one is arbitration, where a third-party neutral arbitrator will make a binding decision on the dispute. And then finally, we have the litigation as last resort. This is a method that is there, but it's expensive for both parties, and it takes a long time could be months or even years to come to a resolution. And sometimes we don't even get the resolution that we're hoping to get. So that's why we always recommend trying to look for alternative dispute resolutions before going into litigation, or as the starting point in litigation. And we also need to document any agreement that we come up with, because just oral agreements, people change their minds, people forget, and people misinterpret. So it's always to avoid misunderstanding, it's always always a good idea to document everything that we can in writing, just so that it prevents misunderstandings and will have a reference point in case of future disputes.
Right. Oh my God. Hey, that reminds me of what a judge said to me once. I know justice has been done when everybody walks away slightly unhappy, right? So you triggered that memory in me, because you said, you're not going to necessarily get what you want, right? But at least you get something, right? And that's the theme of the day, right? So anyways, appreciate you being with us today, Mario. We really got a lot of information. Really appreciate it. The audience appreciates it. So how can somebody just remind us one more time, how can they get in touch with you if they need you?
Yes, our telephone number is 713-684-3550.
All right, so call up that phone number, folks. Get like Mario said, get your legal counsel involved early and often, and kind of avoid these problems up front. You're going to be very well pleased and served. You'll be happy you did, right? So I want to thank everybody out there in the audience for being with us on Legal Talk today. We're wrapping up another wonderful show, knocking it out of the park with great guests and fairly, at least a decent host, I guess. So thanks everybody for being with us. That is the end of our show today, and we will be back. Hopefully you can join us again next time on Legal Talk.
This has been a Now Media Networks feature presentation. All rights reserved.